Being that we find ourselves in the month of Elul, just a few days before Rosh Hashanah, the Jewish New Year, there's a custom to sound the shofar during the month of Elul in preparation for the new year. So if I could have your attention for a moment, we'll sound the shofar now before we start the program. The panelists are welcome to come up and take their seats on the panel. But you can listen along as I briefly blow the shofar for us before we start the program. Thank you very much. 2 minutes, we'll start the program. We kindly ask everyone to please take their seats.
Good evening, and welcome to the 13th Annual Jewish Law Symposium. My name is Ken Rosen, and it is a pleasure to welcome you to this special event. The Jewish Law Symposium has become one of the premier events in the New Jersey legal community, attracting close to 800 participants from across the legal spectrum. I'd like to take a moment to welcome some of the dignitaries that are here in the room joining us this evening. Members of the New Jersey Supreme Court, Honorable James Zazali, Honorable Barry Albin, Honorable Virginia Long, Honorable Ann Patterson, Honorable Janie LaVecchia. Governor Jim McGreevey, Lieutenant Governor Kim Guadagno, Dean of the Rabbinical College of America, Rabbi Moshe Herson, are present this evening. A special thanks to Morris County Sheriff Gannon, who provided security this evening, ever so important. We welcome our distinguished panelists, the Honorable Barbara Bird Wecker, Lawrence Lusberg, my partner at Lowenstein Sandler, Chris Perino, and Rabbi Yitzhak Adlerstein. The Jewish Law Symposium was founded by Rabbi Shalom Lubin, director of the Chabad of Southeast Morris County, an organization that I and my family proudly have supported for many years. At their annual gala this past May, Chabad welcomed 2 of their local teen volunteers with a Teen Visionary Award honoring their work with the less fortunate in our community. And I ask you to now turn to the video screens to learn more about that wonderful project. Thank you.
Teen Visionary Award. Sophia Smith and Oliver Simon have been friends since they were 2 years old and have both engaged in various community service activities over the years. Chabad's C-Teen volunteer Thanksgiving dinners for the Homebound initiative inspired them to create extra helpings delivered, and they have been delivering delicious leftover dinners from their family meals to dozens of low-income seniors on a monthly basis throughout the year. Chabad salutes Oliver and Sophia's success and is excited to present them with our first ever Teen Visionary Award.
This project means a lot to me because it's a really good chance to help people who need it. And I realized that the first time I came here, and seeing the smiles on some people's faces when they got the food and hearing such great reviews about the food, it makes me feel really good. And the fact that it's helping them, it's letting them spend money in other places that they also need. And I've also really enjoyed coming here every time for the deliveries.
Evidently, it means a lot because, especially during the wintertime when we run out of money and run out of food, we've always got these frozen that's coming to help us to get over.
Oliver and Sophia is wonderful people to help us out with the food here, and we deeply appreciate it.
This has helped a lot of people in here, and I thank God that y'all are doing it, really.
You know, in today's busy world, when teens are pulled in so many different directions, to see teenagers spending their time helping others and dedicated to the Jewish values of being lamplighters and being a light unto the nations, there's nothing more heartwarming for me to see.
To life, l'chaim, 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 to life. It takes a wedding to make us say, let's live another day. Drink l'chaim to life. We'll raise a glass and sip a drop of schnapps in honor of the great good luck that favored you. We know that when good fortune favors two such men, it stands to reason we deserve it too. To us and our good fortune, be happy, be healthy, long life. And if our good fortune never comes, kiss to whatever comes. Drink l'chaim tonight. And it stands to reason we deserve it too. To us and our good fortune, be happy, be healthy, long life. And if our good fortune never comes, kiss to whatever comes. Drink l'chaim tonight.
Good evening, everyone, and my acknowledgments and hellos to the panel, to Justice Albin, to his family, to members of the Supreme Court, Justices Long and LaVecchia and Patterson, to, is that fine? Okay. To Governor McGreevey. I note with interest that today, at 3 o'clock on Turner Classic Movies, Fiddler on the Roof was on. And I was home preparing my remarks for this evening. Instead of preparing the remarks, I watched Fiddler. Because frankly, Barry, watching Fiddler is more fun than thinking about you. It's time to get even. Barry Albin, I often get Barry Albin confused with my dear friend Barry Evanchik, but Barry Albin and I were close on the court, and the day after my retirement some years ago, the first call I got the next morning was from Barry. I was so pleased. I knew he was calling to wish me well and to console me because it is a bit of a letdown. And he said, I just want you to know you are no longer Justice Zazali, you are just Zazali. It reminds me of the line of that I'll borrow or steal from the late, great Brendan Byrne. I knew I was no longer Chief Justice when I got into the back of my car and it didn't go anywhere. Now, the rabbi told me I was limited to 5 minutes tonight, and I'm glad he has that sensitivity to lengthy speeches because judges and lawyers can be the worst. My apologies to my colleagues and friends who have heard me say this before, but it is worth noting, by way of being instructive, that Psychology Magazine recently did a study indicating that speeches should be short and that the average length of the average speech should be no more than 12 minutes. And then the study seriously goes on to say that the subject to which the mind turns most often after 12 minutes is sexual fantasies. So if I go on too long, I'll try to give you a good time. Now the serious stuff, because the rabbi gave me strict instructions to talk about Barry the person. It is not to be a roast. And it is my privilege to talk about the accomplishments not so much the accomplishments, but the nature of this extraordinary human being. He said to talk about Barry the person. That's interesting. That's easy because Barry Albin is the ultimate people person. And one of the great qualities of him as a person is something called friendship. He was, to me, one of the best friends I could have on the court, and ever since. But more important than me, frankly, is the fact that he is a great friend to the citizens and the non-citizens of this state. The public could not have a better friend. In both his majority and his many dissents, majority opinions and many dissents, he has steadfastly protected the rights of the people, their constitutional rights, their civil liberties, their human rights. Together with the entire court, past and present, they have been the guardian of the underdog. The court and its individual justices, particularly Justice Albin, have been the sentinel for the underprivileged, the poor, defendants in criminal cases, the handicapped, the elderly, the children, and on and on. He and others, and I'm happy to mention them, just as the justices I just mentioned, Long, Levesque, and Patterson, have been the Praetorian Guard for protecting human rights for all. And sometimes they're alone. When he's alone and in dissent, he becomes quite simply the tribune for the people. He is the custodian for those who need help and those who need hope. Once again, their friendship. Notwithstanding this commitment to the public and to justice and to the court in his 14-hour days, he remains the most devoted of husbands to Ina and to their two boys, just as he was so committed to his parents and to his brothers. I'd like to turn to another side of Justice Albin, and I'm following up on the rabbi's request that I speak about Barry's interest in avocations. It was 60 years ago that Robert Gannon, the president of Fordham University, wrote a book, obsolete now, but a bestseller then, called The Good Old Liberal Arts. And it was about philosophy and theology and history and government and justice and law and literature and poetry and music as being the backbone of our culture and civilization. He was far ahead of his time in bemoaning then, 60 years ago, the fact that the universities and the public were failing to integrate the arts and the humanities into their personal and civic lives. Fortunately, though, that's what Justice Albin has done. It's a cliche, but he is truly a Renaissance man. He has applied those other disciplines to his personal career and his private life. He has woven those disciplines into the very fabric of his life, including music. You may have a hint of that tonight. I am told by Justice Long that he sang at his wife's wedding. I heard for singing for your supper, but that's ridiculous. In literature, he's devoted to the classics. If you have an hour or two, he will debate with you which is the best novel ever written. He maintains it was Anna Karenina. He even argues the point that her name is Karenina rather than Karenina, and you go on for another hour on that. You say tomato and I say tomato. But that shows the depth of his commitment to literature, to history. He could be comfortable in a conversation with an Arthur Toynbee or an Arthur Schlesinger. He knows his history so well. He knows better than anyone I know the nature of the great men of our times in the last century, such as Churchill and Roosevelt, and knows, of course, about the evil and why those men were evil, including the Stalins and the Hitlers. With respect to the subject that's so dear to his heart, law and justice, one of his role models is Justice Louis Brandeis. And understandably so, because he resembles Brandeis in so many, many ways. Justice Albin, like Justice Brandeis, they were and are in the fight for the little guy. With respect to Brandeis, he made a leitmotif of his career the need to increase the reverence for the law and justice. He said famously, quote, "If we desire respect for the law, we must make the law respectable," end quote. Barry, by his opinions, and most of all by his example, has increased the public's respect for the law. Once again, Justice Brandeis saying, If we are to guide others by the light of reason, we must let our speech be bold. Let our speech be bold. If nothing else, Barry is bold. He is not afraid to show his outrage. He is not afraid to speak out on matters which deeply concern him. And you may say, well, that's a natural, but I think as we get older, so many of us tend to tragically care less or far worse, become indifferent. Not Barry Alvin. He shows, as the expression goes, he shows his he shows his private faces in public places. His interest in theology and philosophy, those of you who know him, is legendary. If you ever want a conversation about the important questions, the ultimate questions, those involving philosophy and theology, regardless of what you believe or don't believe, turn to Barry for the most stimulating of discussions. In the 20th century, there were two Jewish philosophers and theologians whom the justice has read and thought about. One is Martin Buber, name known to many of you. The other is, more recently, Rabbi Abraham Herschel. It was almost 100 years ago, 1923, I think, when Buber wrote his classic, I, Thou. I'm sure I, Thou is a book familiar to at least some of you. And it's too complicated and too dense a subject to get into it now. But the I, Thou was this classic, which is now a classic in the annals of spiritual literature about relationships. Whether that relationship is something or someone transcendent, whether it's with another person or a group of persons, or whether it's the planet itself. Relationships. And that, of course, is what is so deeply embedded in Barry Alvin, his reverence, and that's, the only way to put it, his reverence for relationships. It is the key to his humanity. Finally, Abraham Herschel, more recently, as I said, about 30, 40 years ago, wrote avidly in a number of areas. But he said two things that resonate so much today, and I know they're part of Barry Alvin's DNA. He said that racism is man's greatest threat to man. That is more true today than ever before. And then he said separately something interesting. He said, when I was young, I admired clever people. Now that I am old, I admire kind people. Barry, we all thank you for being both clever and kind. To sum it up, your extraordinary commitment to both other human beings, to justice, to both the liberal arts, and to the liberal tradition, separate concepts, have helped to mold the person and the justice that you now are. Those commitments have given you the ability to act with integrity and with intelligence to figure out the right way to go. But more important, they have provided you with the compassion and the courage to then do the right thing. In Italian, we call you simpatico. In the language of some of you, you would call him a mensch. Whatever. We're lucky to have this simpatico mensch in our midst. I say the obvious when I say that our nation and our world, indeed our world, face so many challenges, some existential. We need the Barry Alvins to light the pathway to love and to tolerance so we can walk that pathway in peace together. Governor McGreevey, I understand you're here. You did many fine things for the state of New Jersey, but the best thing you did was to appoint Barry Alvin to our Supreme Court. Thank you.
Jim, thank you for those extraordinarily kind remarks. I am now prepared to say that your 9 months as Chief Justice were the golden age of the Supreme Court. No, thank you for your devoted service on the Supreme Court and to the state of New Jersey in so many different ways. You embody civic virtue and service to others. So I would like for us all to give a round of applause. Chief Justice James Azali. Like a fiddler on the roof, 17 years on the court. Sounds crazy, no? Look at the 2002 photograph of me in the program. That is proof of the irreparable damage that this job has done to me. Fiddler on the Roof is one of the all-time musical classicals, a play that evokes universal themes as relevant today as when it opened on Broadway in the 1960s. To be clear, I am a Fiddler junkie. As a young teen, I listened to the Fiddler album countless times and to the voice of the great Zero Mostel, who played the leading role of Tevye. Back then, I wondered, why did parents name a young boy Zero? And did he go around with the nickname Bupkis? Like many of you, I have seen the movie and the play. My present law clerk, Joshua, performed in the national tour of Fiddler. And as a young associate at Wilentz, I performed the role of Tevye in a one-person parody at the annual holiday party. More about that at the end of my remarks. Let me begin with some background to the story to inform the discussion of the lessons that we can learn from Fiddler. Fiddler takes place in 1905 in the fictional town of Anatevka, a shtetl, a small village somewhere in Russia in an area designated for Jewish settlements. Russia then encompassed the Ukraine and what is now present-day Poland. The Jews in Anatevka live in an uneasy peace with their Christian neighbors. They also live in fear of a pogrom, state-sponsored terrorism and violence directed at Jewish communities. In 1905, a revolutionary fervor is sweeping Russia. Not even little isolated Anatevka, ruled by the age-old traditions of the Jewish faith, is far removed from the upheavals of the world about it. The main character is Tevye, a poor milkman who lives with his wife Goldie and their 5 daughters. Tevye pours out his complaints and his heart in an ongoing, unrequited dialogue with God. Now, I have those dialogues too. But the only answer I ever receive is from the Chief Justice. The main storyline revolves around Tevye's daughters and their challenge to the patriarchal tradition of arranged marriages. Tradition is the organizing principle of life in Anatevka, dictating how people dress, what they eat, and whom they marry. Tevye says, "How did these traditions start? I don't know. Tradition. Without our traditions, our lives would be as shaky as a fiddler on the roof." Now, I hope I'm not scaring anyone with my little Tevye dialogue there. By tradition, the father arranges and approves the marriages of his daughters. But Tevye's 3 eldest daughters want to choose whom to love and whom to marry. Tevye arranges the marriage of his daughter Zeidel to the wealthy butcher. But Zeidel is in love with a poor tailor. Tevye makes the first exception to the tradition of paternal privilege. He bends for the sake of his daughter's happiness and gives his permission and blessing for her to marry the poor tailor. When Hodel, his second eldest daughter, announces that she and her boyfriend, a young revolutionary, intend to marry, she does not ask Tevye for his permission, just his blessing. And then Tevye ponders over the unraveling of his patriarchal prerogative. He says, "One little time I pulled out a thread, and where has it led? Where has it led?" And then he gives his blessing and his permission for them to marry, because he knows they are in love. When his third daughter, Chava, tells Tevye she has married a young Christian villager with whom she has fallen in love, tradition has reached a breaking point. For Tevye, marrying out of the religion is an existential threat to the Jewish faith and to his entire belief system. As Chava begs his acceptance, Tevye engages in this dialogue with himself. Accept them. How can I accept them? Can I deny everything I believe in? On the other hand, can I deny my own daughter? On the other hand, how can I turn my back on my faith, my people? If I try to bend that far, I'll break. On the other hand, there is no other hand, no Chava. And then we hear the chorus of tradition. Tradition commands that Chava is dead to him. Not even tradition, however, can extinguish his unspoken love for his daughter. At play's end, Chava comes to bid him farewell. And although Tevye will not acknowledge her, he says quietly, under his breath as she leaves, "God be with you." However insulated Anatevka may be from the world, it is not immune from the political and social spasms shaking Russia, nor immune from the latest wave of anti-Semitism. First, the village suffers a mini pogrom, and later the local constable, the prototypical Russian apparatchik, announces that the entire Jewish population of Anatevka must pack up and leave. So Tevye loads his meager belongings onto a cart, and with Golda and their two youngest daughters, they set out on their journey to America. So what can we learn about from Fiddler, about tradition, persecution, and immigration? Let's begin with tradition. We have our traditions in the law. Why do lawyers say, "May it please the court," when they know what they're about to say is not going to please the court? Tradition. Why, when I come on the bench, do I take the seat to the immediate left when I really want to sit in the best seat in the House, front row center? Tradition. Tradition allows us to share common and cherished values, infuses meaning into our mundane lives, and guides and comforts us in our daily ways. Tradition brings predictability and conformity, but it can also oppress. Tradition has been the rationale for repression and discrimination throughout the ages, a justification for a privileged class of people keeping downtrodden a disfavored and powerless class. At the time of the founding of our republic, women did not sit in the Continental Congress or the Constitutional Convention, nor were they able to fully participate in civic affairs. Tradition. African Americans were enslaved and later, when freed, denied their civil rights as equals in society. Tradition. Many odious traditions have been codified into law. The struggle of women and African Americans, and now the LGBTQ community, to attain equality in our society in many ways has been a struggle to overcome tradition. Certain traditions may be central and sacred to a faith, a creed, a way of life. But we learn in Fiddler, as we do in life, that tradition cannot hold back the irresistible power of love. What is the role of the democratic process and the judicial process to alter traditions codified into law that discriminate and oppress and deny persons the right to marry whom they love? To alter a tradition codified into law, whether through the democratic process or our judicial system, takes time and an enlightened public. The immutable principles in our Constitution tell us that the government cannot deny a class of people the equal protection of the laws or due process. But such principles are tested in the real world. Our inalienable rights depend on an enlightened public and courageous courts. However, courts often will not bend to tradition to protect the rights of a marginalized or disfavored class of citizens unless there is a critical mass of public support. That has been true about the right to marry. In 1967, the United States Supreme Court invalidated Virginia's criminal statute banning interracial marriages, and in the process, a similar ban in 16 other states. Chief Justice Earl Warren wrote, "Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." By that point, the cause of civil rights had won acceptance in Congress, in our courts of justice, and in the court of public opinion. The majority of people did not believe that laws banning interracial marriage accorded with our contemporary values. But the United States Supreme Court had the opportunity to pronounce Virginia's statute unconstitutional 12 years earlier. In 1955, a Virginia couple, a white woman and a Chinese man, married in North Carolina. When they returned to their home state of Virginia, the Virginia Supreme Court ordered their marriage dissolved. Ultimately, the United States Supreme Court declined to review the case, not because the justices believed that the Virginia law was constitutional, but because of the timing. Just 3 years earlier, the court struck down the separate but equal doctrine in Brown versus Board of Education. The justices feared that invalidating the ban on interracial marriage at that moment might incite violence and impede the enforcement of the integration of public school systems throughout the South. In 1955, despite the Brown decision, not a single black child attended school with a white child in 8 states in the South. The court waited for another day when public opinion ripened before undoing the tradition of white supremacy codified into the marriage laws of the South. In 2015, the United States Supreme Court in Obergefell v. Hodges held in a 5-4 decision that the 14th Amendment's promise of individual liberty guaranteed the right of same-sex couples to marry. But consider this. During a good portion of the second half of the 20th century, gays and lesbians were barred from holding many positions in government, and barred from serving in the military. The police targeted them, and our immigration laws excluded them. And many states criminalized same-sex intimacy. Indeed, in 1986, less than 30 years before Obergefell, the United States Supreme Court in Bowers versus Hardwick held that the Constitution conferred no right of privacy to same-sex intimacy and upheld the laws of 25 states that made it a crime. What happened between those years to bring about such a revolutionary change in the traditional definition of marriage codified in the laws of every state? The language of the 14th Amendment did not change. The nature of the injustice did not change. Instead, the public's consciousness of the injustice perpetrated by tradition changed. For one, a committed civil rights movement took shape in the 1970s. In the next 40 years, society gained a better understanding of the rights of members of the LGBTQ community to live and work as equals in our society. Through greater public awareness advanced by popular culture and the media, society began to fasten onto an undeniable truth. The people in the LGBT community are our mothers and fathers, our brothers and sisters, our friends, our coworkers. During this period in New Jersey, comprehensive legislative enactments and judicial decisions, step by step, extended protections to the LGBT community, making it unlawful to discriminate against individuals on account of their sexual orientation. The United States Supreme Court slowly took up the march. In 1996, it struck down an amendment to the Colorado Constitution that codified the right to discriminate based on sexual orientation. In 2003, it overturned Bowers. In 2013, it invalidated the Defense of Marriage Act, which barred federal recognition and federal benefits to same-sex marriages that states had made lawful. Then followed the 2015 Obergefell decision, which guaranteed the right to same-sex marriage. As Tevye says, pull one thread, and where has it led? And this is where it led. By 2015, the critical mass of public support had been reached. The District of Columbia and 16 states, including New Jersey, had already legalized same-sex marriage. In a perfect system of justice, our rights should not depend on public opinion or the sentiments of the time. Equality should not take generations to achieve. But consider Justice Kennedy's words in Obergefell. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights in the 14th Amendment did not presume to know the extent of freedom in all its dimensions, and so they entrusted to future generations a charter protecting the right of all persons to enjoy liberty as we learn its meaning. Did blacks not know the nature of injustice in the 100 years between the passage of the 14th Amendment and the recognition of their civil rights by legislation and judicial decrees? Did gays and lesbians not know the nature of their persecution in the years before their rights were recognized? The simple truth is that constitutional guarantees may not be guaranteed unless there is a critical mass of public support for the rights of a disfavored class. Alexander Hamilton conceived of an intrepid judiciary protecting our rights. But courts do not operate in a vacuum. Judges may be affected by the same prejudices and traditions that blind their fellow citizens. Yes, courts can and should lead the way in protecting our rights, but a critical mass of public support often is necessary to strike the death blow to a long-held tradition that oppresses. The promise of our Constitution depends on an enlightened public. Every successful civil rights movement has educated the public about the nature of the injustice while seeking vindication in the courts. The majority and dissent in Obergefell battled over whether the democratic process or the judicial process was the appropriate forum to end a historically and religiously recognized tradition codified in the laws of our states and nation. In his dissent, Chief Justice Roberts viewed the five-member majority as usurping the democratic process by invalidating the marriage laws of more than half the states. He rhetorically asked, "Just who do we think we are? Who do we think we are?" The majority in Obergefell gave its answer by saying that we are a humane nation with a national charter that guarantees liberty and equal protection of the law to all, even to those marginalized by tradition solely on account of their sexual orientation. Who knows, today, with changed attitudes and tradition, even Tevye might accept an interfaith marriage of his daughter. That's if he's in the reform or conservative movement. Let us now talk about persecution immigration. The persecution of Jews strengthened and reinforced their traditions that fortified them against the hostile world. Compelled to live within their insular communities, Jews clung tightly to their faith and married within their religion. In some sense, assimilation has posed a greater threat to Judaism and religious traditions than persecution. When Tevye is told by the constable that he and the villagers must leave their homes, at least they have some place to go to escape the persecution, the pogroms, the terror, the indignities. They can go to America. From 1881 to 1920, tens of thousands of Jews died in pogroms in Russia, and another 500,000 were left homeless. No wonder that between those years, 1.5 million Jews immigrated from Russia to the United States, and another 1.5 million to other places, such as Palestine and parts of Europe. During those years, the United States did not restrict the number of immigrants entering into the country, except for the Chinese, who were barred by the racist Chinese Exclusion Act of 1882. The words on the pedestal of the Statue of Liberty, "Give me your tired, your poor, your huddled masses yearning to breathe free," were not empty words or a forlorn hope to a threatened and persecuted people who were milkmen and common laborers. Between 1880 and 1920, our doors were open not only to the well-educated, the well-connected, the highly trained, yearning to score big in America. Tevye and his poor family and other such families, and not just Jewish families, were welcome. The open immigration policy, which allowed Tevye and others to seek sanctuary in this country, ended when nativist and populist sentiments took hold in the 1920s. In 1924, Congress passed the National Origins Act, which restricted the annual number of European immigrants to 150,000 based on a quota system. It also passed the Asian Exclusion Act that all but banned immigrants from anywhere in Asia. How would Tevye and his family have fared as a Jewish family in Germany seeking refuge in this country in the 1930s. Between 1933 and 1940, which includes the period after the onset of the Second World War, the United States allowed in little more than 100,000 immigrants fleeing Nazi persecution, a pitifully small number compared to those who sought sanctuary here. The State Department tightened visa restrictions even as German Jews faced intolerable repression and persecution. In 1938, the State Department admitted 10,000 fewer Jewish immigrants than allowed by law. That was the year of Kristallnacht, the night of the broken glass, when a German state-sponsored pogrom led to the deaths of nearly 100 Jews, the arrest of approximately 30,000 Jews, and the destruction of approximately 1,000 synagogues and 7,500 businesses, Jewish businesses. In the spring of 1939, just 6 months after Kristallnacht, the United States government turned away the luxury liner St. Louis, carrying 937 Jewish refugees, including 400 women and children, despite the anguished pleas of the desperate passengers. Eventually, the passengers were received in various European countries. But after the outbreak of war in 1939, Nazi Germany occupied most of the European continent. At least 251 of the passengers of the St. Louis perished in Nazi concentration camps. During this period, closed borders for Jews was the equivalent of a death sentence. The book of Exodus reminds Jews that they were once strangers in a strange land and to embrace the strangers among us. All of us, Jews and non-Jews alike, are the children of immigrants, however many generations removed. All were strangers once who came here to escape religious persecution or other forms of oppression, or who came here in search of a better life and to experience freedom. This country, a land of immigrants, has opened its arms to the Tevyas of the world, the homeless, the tempest-tossed. Let us not forget that immigrants have made our nation not only the most diverse, but also the greatest on earth. Fiddler is a musical, so it is fitting that I should end on a musical note. While an associate at the Willents firm, I played Tevye in a parody called Fiddler of the Firm. The storyline was about the struggle of the oppressed associates to get to the partner land. Are there any associates here in this audience? Okay. If there are, this is for you. So here's a little piece of that performance with an update. Dear God, you've made many, many associates. I realize, of course, it's no shame to be an associate, but it's no great honor either. Would it have been so terrible if I were a partner? If I were a partner, all day long I wouldn't write a brief. If I were a shareholder, I wouldn't have to work hard. Every day would be a holiday. Diddle, 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 dum. I would ride around in a great big Mercedes with a sunroof and a fancy stereo. I'd arrive at 10 and be gone at the strike of 3. I would surround myself with a dozen paralegals and a couple of associates just for show. And everyone would say I'm in the know. If I were a justice, now that would be a miracle of miracles. Wonder of wonders, miracle of miracles. The gov took a lawyer from Willents, put him in robes, and miracle of miracles, named him to be a justice. I think my 20 minutes are up. I just got... I do not do bar mitzvahs or weddings, but I do take petitions for certification. Thank you, l'chaim, and enjoy the rest of the program. Thank you very much. Thank you.
Wow. That was incredible. Thank you, Justice Albin, for your beautiful remarks. Thank you for your voice. That was amazing. That was amazing. And it's an honor and privilege to have you on the bench here in New Jersey. And I thought of a new expression now, which is, Justice Albin, laugh now, but one day you'll be able to watch Fiddler on the Roof 3 o'clock in the afternoon as well, right? Welcome, everyone, to the Jewish Law Symposium. It's great to have everyone here. We have a lot of ground to cover, and we're going to move along and cover it rather quickly. A gentleman, a friend of mine, took his grandfather to see Fiddler on the Roof in the 1960s. His grandfather came from a small shtetl back in Europe in the old country, and his grandfather, an elderly Jewish man, sat through the show with Zero Maistel. And on the way out of the show, they turned to him and said, Zayda, so what do you think? He said, that's how it was. That's how it was. That's how real life was. Who here, by raise of hands, had a chance to see Fiddler in Yiddish? Raise your hands. Okay. So on one hand, habe ich getracht zu sich, als es wollte werden kedai, als ich so reden heint bei Nacht nur in Yiddish. But on the other hand, I realized that, Chris Perino, some of the other members here, Yiddish may not be your strong point yet, though I thought if you're thinking of jumping back into a government, the Israeli government right now could kind of use a little help, and Yiddish may come in handy. Just something to think about as we move forward. We want to introduce our distinguished panelists. We have Chris Perino, who is the chair of the litigation department at Lowenstein, past Attorney General of our state. Barbara Bird-Wecker, Justice Wecker from the Superior Court Appellate Division. So wonderful to have you here on our panel. Larry Lusberg from Gibbons, a noted civil rights attorney, very prominent panel, and Rabbi Yitzchak Adlerstein, who, in addition to being a well-known Talmudic scholar, is the director of Interfaith Affairs at the Simon Wiesenthal Center, dealing with persecution, discrimination, and all of these matters. So we look forward to a fascinating panel. A few housekeeping notes. We are going to end the program promptly at 8:30 to the minute. Rest assured, we have challahs for everyone on the way out at the right time. So let's settle in and do some and have some fun. Some quick thank yous. I want to thank all of you for joining us tonight. I want to thank all of our corporate sponsors, all of our table sponsors. A special thank you to Ken Rosen for your incredible support, to RWJ Barnabas for your support, to my brother Mendy, who is such an integral partner and part of our organization, to my wife Arona, who takes care of our 8 kids and me, which is no easy task, and to everyone that helped make this project possible. We're very, very grateful to you. On a more somber note, I want to pause for a moment and dedicate tonight's program to the memory of my mother. My mother passed away earlier this year. She was incredibly proud of this program and all of the programs that I've been privileged to run, and we dedicate this program to her. I want to also remember a very special friend of ours here at the symposium, my dear friend Hal Braff, who was an incredible mensch, incredible attorney, incredible figure in the New Jersey community, and a very close personal friend of mine. It was his vision that helped me turn this project into what it's become. And he was president of the Rabbi Lubin fan club. So we miss Hal dearly and know how much he would want to be joining us tonight. Also, I want to just mention, for those of you that get our weekly Jewish Law Symposium quote of the week, we've been sending out a weekly quote of the week every Friday with a little one line of the Talmud or Jewish ethics or values. If you want to get it, let me know. We could sign you up. We talk about tradition, and we'll talk now, moving away from the global discussion of tradition, getting into traditions within firms a little bit, but as our tradition here at the symposium is, we'll turn to the screens and go to clip number 1.
A fiddler on the roof. Sounds crazy, no? But here, in our little village of Anatevka, you might say every one of us is a fiddler on the roof, trying to scratch out a pleasant, simple tune without breaking his neck. It isn't easy. You may ask, why do we stay up there if it's so dangerous? Well, we stay because Anatevka is our home. And how do we keep our balance? That I can tell you in one word. Traditions!
Tradition. So let's talk a little bit, just as Albin spoke about changing traditions on the broader scale of courts and law and justice, let's get into firms a little bit and to some of the changing traditions that have taken place over the past few years, over the past few decades within law firms. And I'd like to begin with you, Larry. Tell us a little bit of what you've observed of how traditions within law firms have changed over the course of the past couple of years.
Yeah, so it's still funny to me that I'm asked about the last couple of years, as if I've been around a while, but I am definitely getting older and can talk about traditions. So at the end of the clip that you've just seen, Tevye says, traditions. Without our traditions, our lives would be as shaky as a fiddler on the roof. And I think our traditions in the law have been shaky over the 35 years that I've been practicing law. And it's important that they be shaky, because it's important that we all understand that it's very delicate what we do. On the one hand, we love the professionalism of being lawyers. We love calling ourselves lawyers and doing the things that we do. But we have to, as Justice Albin really said, question those things and wonder every single day whether it's right. So is it right that we should all work till 9 o'clock every night and kill ourselves the way lawyers traditionally did? Is it right that after that we all go out to dinners and events like this with other lawyers? Or is the tradition breaking down in a good way, in the sense that people are trying hard to balance life, work life with family? These things are hard for those of us who have been around for a while to see that things really are different. In some ways, it's innocuous, right? I mean, citation form isn't what it was. And in some ways, it's actually really bad. I mean, the tradition was, when I started practicing law, and for a lot of people here, August was, you pretty much had it off, right? I mean, August was a vacation month. Now we all work through August, and even when we go on vacation, we have our cell phones, and we're kind of working and doing emails anyway. but the balance of the way it was, which is good, and rescuing and remembering that which is good, while welcoming that which might even be better, is the hard part. We always have to remember, though, that as we do it, we're fiddlers on the roof, that if we slip, as Tevye says, we might break our neck. And we can break our neck by not be welcoming to the next generation of lawyers who want to do things differently for good reason. And we might break our neck by not adhering to the traditions that make being a lawyer really, really special. So to me, what Fiddler on the Roof stands for is the battle to be open to change. Barry talked about, Justice Albin, sorry, talked about so when I first met Justice Albin, he was just Barry. He was just a defense lawyer like me.
Was he an associate?
I think he might have been a paralegal, I think. So I think that, so to me, the tradition of law firms is a great thing. I work at a law firm that is full of traditions. We have, one of our traditions is we have this amazing St. Patrick's Day celebration, and you know, bagpipers walk around Gibbons, you know, and play, but over time I've noticed that people close their doors because they get annoyed at the bagpipers, and that's okay, because it's okay to have the diversity that really engenders. I think that that tradition is important to have, and it's important to welcome breaking it down. And that's kind of in all of our lives, but it's part of being a lawyer too.
Chris, jump in over here. Give us a little bit of a different perspective. Your firm's been around a long time. While you're a prominent partner, you're from the newer generation at your firm. Give us your perspective of the traditions within a firm, the changing traditions, and the newer generations, the younger partners who are coming in and shaking things up a little bit.
Let me just start by thanking Justice Albin for his incredible service. I mean, really just amazing. 17 years of commitment to what's important. And I'll just point out that you didn't really seem as funny, as musical, or whimsical when I was appearing before you as Christie's Attorney General. You stuck to your guns. You know, just today, we had a program for the entire litigation department, to which we invited other interested lawyers and staff to talk about something that I think has not been a tradition in law firms generally, which is to talk about why people leave. Why people leave the law, why people leave law firms. In our case, we have a strange phenomenon where we've had over the years, the last 15 years, 40 people leave and come back. And we had an open dialogue today with 100 people in the room about why people decided that they should leave. And I think it's not something that lawyers like to talk about. They don't want to talk publicly. You don't want to tell your partner that you're thinking about going to do something else, going to work in government maybe, going to work in-house, going to another law firm. And what we've tried to do is sort of break down that tradition and encourage people to come forward and talk to us about what they really want to do. You know, not everybody wants to be a partner in a law firm anymore. You know, that when I came up the ranks, that was it. You would never dare say that you wanted to do something other than be a partner in the law firm you were working at. That's not what everybody wants to do. And so we are, you know, just happens to be today, trying to break that tradition and open people's minds to having a conversation where, you know, we might actually be able to help you. Even go to a different law firm if that's what you want to do. When a partner of mine who's here, Michael Himmel, and I left a law firm a long time ago, a lot of years ago, it's very different then than it is when you leave a law firm now. You leave Lowenstein Sandler today, we throw you a party. And then we invite you back to alumni dinners. So that's just a snippet from today's events.
Judge Wecker, jump in over here. Give us some of the changing traditions you've observed over the bench for judges and how those traditions have kind of shifted over time?
Probably fewer changes in the traditions in our bench in New Jersey. But what strikes me as I think back, in the days when New Jersey had enough money in the budget to send judges out of state for continuing education, we got to meet judges from other states with other traditions. And it came as something of a shock in one of the sessions to discover that one of the judges from Texas had his pistol in his breeches. Tradition has two sides. There's a lot that's romantic and good sounding about tradition, but another word for tradition could be inertia. And to the extent that tradition has kept us from some changes that would be welcome, it's not always such a good thing.
Thank you. Now, Rabbi, help us out over here, because we're talking about tradition, and we're kind of lumping in, and there have been some critics, I didn't end up including it in the paper, some critics of Tevye who come along and say that Tevye seems a little confused because all of his ritual and all of his practices and all of his commandments, so to say, are all lumped into the word tradition. From the Jewish law perspective, in traditional Jewish life, is there a difference between law and tradition? How would you break down Jewish law and Jewish tradition? What changes and what doesn't?
To put it briefly, not a kind thing to say, but Tevye was wrong. He was wrong. Without tradition, we would have survived. And we did survive without tradition because we had something that was stronger than tradition. When Tevye and his wife set off on that journey to America, what they wound up with was a generation or two later, people who would look back at Anatevka and they would find their past, but not their present, and certainly not their future. Traditions are plastic, malleable, sometimes Teflon. There's a German proverb that he who is married to the spirit of the times will quickly find himself a widow. Traditions can change and should change, but there is more than tradition. And I don't think I have to invite people in this room who practice the law. The law goes well beyond tradition. Not all law, because many laws can be changed, should be changed. I thank Justice Albin for a magisterial presentation on what it takes for a society to change some traditions. But there's a tradition of the specialness of human beings. I think a lot of Justice Albin's passion when he delivered that stems from what some people today are saying is a tradition that should change. Thinking that there is something exceptional about the human state is speciesism, and we've got to wipe it out. Other people are arguing that the next form of human evolution is shifting to silicon, because it'll do a far better job on less energy. We're sitting here, to a large extent, you don't have to listen to this, and all that, but we're sharing the largesse of not only of Rabbi Lubin, but of Chabad worldwide. I'm not a member of Chabad. I am what Chabad calls a snag. Rabbi Lubin will explain that later. But
I have no idea what you're talking about.
But there is no question that Jews and non-Jews around the world stand in awe of what an army of people devoted to the Jewish people and humanity do at great personal sacrifice. There's no such tradition within Chabad. There is something stronger than tradition, and that is a faith in some things that are held to be immutable. Tradition is important, but if we spend too much time talking about tradition, we lose sight of the fact that not everything can change. The Supreme Court will not overthrow the law of gravity. no matter how many people clamor for it. There are things, perhaps even in human psychology and in the way civilizations have to hold together, that go beyond. That's where I think we find law. Jewish law distinguished itself in a number of ways. And I'm going to be very careful not to get to the 12-minute mark because I don't want to ask people what they're thinking about after the 12
30
minutes.
seconds.
Okay. One of those is that Jewish law deals not only with law, but going beyond the letter of the law, and then uses legal thinking, the same tools it uses in teasing apart complex legal issues, to talk about the supererogatory, to talk about going beyond the letter of the law. The Talmud says that the temple was destroyed because people followed the law. And the Talmud says, what do you want them to follow? It says, no, what we mean is it was destroyed because people did not go beyond the letter of the law. And Jewish law found a legal terminology to deal with issues going beyond the letter of the law. That's my only concern, that we not lose sight of that in this discussion.
Thank you. Moving on, we talked about persecution. We talked a lot about pogroms and all of the persecution that they experienced back in Europe. We're going to talk a little bit about representing people who are unpopular, who may be repugnant, according to RPC 1.16b4. One has no obligation to represent a client who one deems to be repugnant. How exactly do we define that? So we'll turn to clip number 2 and get this show on the road.
And most important of all, our beloved Rabbi.
Rabbi, may I ask you a question? Certainly, Leibish. Is there a proper blessing for the Tsar?
A blessing for the Tsar, of course. May God bless and keep the Tsar far away from us.
I guess they didn't have the option of just impeaching a czar whenever they wanted to, right? Had to throw it in somewhere. You know, people asked, how'd you come up with this topic? I said, you know, there's been nothing going on in Washington the past couple months, and it's just been quiet, so we thought we'd talk about Fiddler. But here you have a czar, you have real anti-Semites, they're really bad people in this world, and as a rule, I have yet to see bad people who can't find representation. There's always someone willing to represent them. Everyone's entitled to representation, but as an attorney, should you represent someone you deem to be a czar, despicable, repugnant, use whatever word you want? What is the balance between those two? Chris?
If we didn't represent people who are unpopular, we'd be out of business. That's what we do. At least in my area of the practice, we represent people who are in trouble, who've been accused, who themselves may have been persecuted. My approach, which I think is different than probably many others in the room, is I try very hard not to make judgments about people based on their beliefs or their politics. I tried very hard as Attorney General to stay out of politics and to stay true to what I thought was right. And it makes it easy for me in the representation of private individuals now in companies. I really, unless it's something that is going to cause the law firm true harm.
Give me an example.
Well,
theoretical.
A theoretical example, which is not so theoretical, is representing the interests of the President of the United States. You know, we've seen it. There are law firms that have undertaken representation of the President in his own private pursuits, and clients have walked out the door. There's real risk associated with a decision like that. I'd like to think that I would make that decision on a principled basis, but reality creeps in to that analysis.
Larry, help us out over here.
So when I started at Gibbons, some of you may know I run this Gibbons Fellowship Program, which takes on constitutional causes, often unpopular ones. I remember early on I took on a death penalty case that was really particularly horrific, and began a course of representing murderers on death row around the country. And I thought that made me very unpopular at times in my firm. And then, when Megan's Law was enacted, I decided I would represent sex offenders in challenging Megan's Law, and that made me very unpopular in the town of Chatham, where I live. And then I was assigned to a case that I really liked, in which a sex offender was trying to get playboys brought into the prison where he was, and I was vigorous in my sense that that violated the First Amendment, and that made me very unpopular with my mother, which actually had certain benefits. But I really truly believe that we have an obligation to represent the most despised among us, and I've spent a lot of my career representing people on death row, people in Guantanamo, enemy combatants, people who deserve the benefits of the law no matter what they've done. Having said that, I think we need to be clear about it. There are limits on who we have to represent and should represent. I do believe that, obviously there are conflicts that we have to run, and when there are conflicts of interest, we can't represent people who are in conflict. And obviously, as Chris pointed out, there are business realities that creep in, and sometimes we don't represent somebody because it will be bad for the business of our firms. But sometimes...
Do you let clients make that determination? If clients say, we don't want you to represent that guy, how much of a voice does that have?
So I'm not the boss of my firm, and I don't have to make those tough calls.
Where's Mike Griffin?
But it's a reality. I mean, before I can take in a case, our firm makes a decision about whether that will be a good or bad thing for the firm. It's not what the clients think. It's what the overall, in order for us to survive and for me to represent all the many people, and they're very tolerant of my ability to represent really unpopular causes. Justice Albin talked about the LGBT cases. When I started doing those LGBT cases, they were very unpopular. And by the way, I should say something about that, because one thing that Justice Albin pointed out, and he's right, is that social change comes about in part because the public changes its views of things. But it also comes about because there are courageous lawyers, and there are a lot of them in this room, who are willing to take on those unpopular causes and try to make the world a better place. And I applaud all of you who do a lot of that day in and day out. It's important that we have the courage to do that at times. But it's also important that we know if there's a case, if there's a person or a case, and I'm not saying the president would be that for me, although he would, there would be such anathema to what I believe. It would be wrong for me to take on that case because I have an obligation to represent my clients zealously. And if I can't represent them zealously, I shouldn't take on the case. You can criticize me, as my mother did, if you take on something that you don't believe in. But I think you have to have the sense that you really care, that you're really going to do the right thing before you take on a case, and that you can do that, accomplish that zealous representation. If you can't do that, you shouldn't take the case, and that's my measure. If I don't think I can do it right, I won't do it.
Rabbi, you work for the Simon Wiesenthal Center. Simon Wiesenthal Center has dedicated itself to Simon Wiesenthal hunted down Nazis, to bringing about tolerance, fighting injustice, representing Nazi war criminals. There were articles recently about Ben Ferenc, who's the last surviving prosecutor of the Nuremberg trials. He's 99, he lives in Florida. Morally, do you represent a Nazi war criminal, or do you say, I'm not going to take that kind of case?
Our system of justice demands it. Our legal system holds open to every person the right to a trial and to vigorous defense. And I think in the end it boils down to the something similar to the old adage about people and the wonder stories of great Hasidic rabbis. And we used to say back in Europe that somebody who believes none of the stories of these wondrous rabbis is probably a heretic, and somebody who believes all of them is probably a fool. Everyone out there we should all feel obligated to uphold the legal system, and that means from time to time taking on cases that we don't particularly like and find loathsome. There are people out there who seem to specialize in them, and might as well hang out a shingle specializing in sleazebags. That often points to some kind of a character defect. But I would say, to answer your challenge, yes, even the Nazi criminal is entitled to that defense, and somebody should do it.
Judge Wecker, when you're a judge, you're involved in a case, and someone in the case would be deemed repugnant under normal circumstances. How do you put aside your own personal sentiments and feelings when judging a case that comes before you, where one side or another, or possibly both, are just people or share views or have done things that you just can't wrap your head around?
Two thoughts in particular come to mind. Before you asked your question, listening to the distinguished members of this panel with whom I'm privileged to sit tonight, I'm struck by the fact that when you're a judge, one of the luxuries you have, apart from giving up the opportunity to make partner and drive that Mercedes, is that you don't have to worry about what clients are going to think. You don't have to worry about what business you're going to get or lose. The business comes to you. And that is, in fact, a luxury. The other side of that, as you just pointed out, Rabbi, is that sometimes cases that come to you do involve people. Probably it happens more on the criminal side than on the civil side. Happens in the family court also. People come before you of whom you personally might disapprove. And that gets to an issue that's gotten a fair amount of attention in the law and in psychology that's come to be called inherent bias. And that is that all of us have an obligation in our roles to recognize that we are as subject to inherent bias, things that we might have picked up along the way from the time we were little children, whether it was language that a grandparent used or that we heard around the house. And I think the thing we learn, or hopefully we learn, is not to pretend those biases don't exist, but to recognize them, deal with them, discount them consciously, but on the other hand, not overcompensate. And that is one of the challenges sitting on the bench.
Chris, you wanted to jump in.
I just think there's an interesting distinction between, I'll just use the colloquialism, not having the stomach or not having the desire to represent a child pornographer, let's say. I get that, and that kind of work is not for everybody, and for the people who it's not for, they shouldn't do it. But to not represent the child pornographer because you don't agree with his political views, to me, is off. The rule, professional conduct that you cited, and I guess there's some ethics credit, so we'll talk about it for 15 seconds, doesn't talk about taking on the representation. That's up to us. We decide who we want to represent and not represent, and we make that decision freely every day. That's about withdrawing. And I think it's an important distinction. And thankfully, the rules also say that, the views of your client aren't your views. Rule Professional Conduct 1.2 says you don't necessarily own those views. And so I try in my own practice, where I think I can be helpful, where I think I can provide a good and zealous representation, to undertake that work and try not to think about what that client's or that company's political views or other unrelated views might be.
Stick to the law. Rabbi, the Bible gives us some pretty clear instruction for judges in a Beit-Din type setting of how to view litigants and defendants. Could you share with us a little?
What do you mean, litigants?
Meaning, you have people coming before you that may be of disparate incomes and wealth, and one's a good guy, one's a bad guy. What's the biblical perspective to a judge as to how to view litigants who come before you in a case?
The Talmud is pretty clear about this. Remember, in a Jewish court, there are no attorneys. There's some other advantages to Jewish courts. I once met Justice Kennedy at Loyola Law School, who said that he's a great admirer of Jewish law because he heard that when the court comes to a decision, they do not have to file a written record of their reasoning. He would love to be governed by Jewish law. In Jewish law, there are a couple of rules. I'll go over them very, very briefly. One is that the Mishnah, part of the Code of Jewish Law, earlier than the Code of Jewish Law actually, talks about the obligation, the psychological obligation of the judges. It's a panel of judges, not a jury that tries cases. They should look at all the people in front of them as if they are as guilty as sin, and suspect collusion, suspect deception, suspect the worst on both sides, because it's the only way you're going to get to the truth. And after things settle down, after you arrive at the verdict, then everybody should seem to you as an angel. Getting there, both parties have to appear before you as equals. The Talmud says if you have a rich person and a poor person coming into court, and one of them shows up in an Armani suit and the other one's dressed pretty much in rags, you tell the Armani guy, you either send out for an Armani suit for your opponent, or we'll get you some rags. Because how they appear before the judge in court does create an inherent bias, and they have to appear as equals. So much of what we suffer in terms of the popular conception of law is the idea that the rich get a much better shot at the law because they're the ones who can afford better representation, and there's this perception of inequality in the way we do law. And there is some truth to it. In Jewish law, that is pretty much covered.
And we'll continue on that point when we talk about pro bono things a little bit later. Let's go to clip number 3. We're going to move the discussion on to immigration, an easy, mild, friendly topic to discuss these days. And take a look at the clip mentioned
Tell me, how much
earlier.
time do you need to sell your house and all your household goods?
Why should I sell my house? Is it in anybody's way?
I came here to tell you that you are going to have to leave Anatevka.
And how did I come to deserve such an honor?
Not just you, of course, but all of you.
So the constable tells Tevye that he's going to have to leave his home. Let's get into the topic of immigration just a little bit. A lawyer has an obligation to uphold the law. So the question is, when you have ICE, do you cooperate with ICE? Do you not cooperate with ICE? Is this an individual decision based on one's own morals or values? Does a firm make a determination of we will cooperate, we won't cooperate? The judge mentioned judges in different parts of the country. Does everyone, every law firm in the country decide for themselves, we will, we won't? What are the moral issues we deal with on this? Larry, start us off here, please.
Thanks. So that's a really interesting clip. And it's a really interesting clip because as bad as the news is that the constable is delivering, look what he's doing. He's engaging in a little bit of an act of civil disobedience. And throughout Fiddler, he does this. He warns Tevye when the little pogrom is going to come so that they can prepare for it. And he doesn't allow him to actually be evicted forcibly. He gives him a little bit of a heads up. And it's just an interesting aspect of sort of being of the play that there's always an ambiguity in a way as to who's the good guy and who's the bad guy. I mean, Tevye in some ways is such a good guy. You want to root for him the whole time, but he's so mean when he won't embrace his daughter who marries outside the faith. The ambiguity of who's the good guy and who's the bad guy is always what makes life interesting, and literature and plays for sure interesting. But to, so now that I've treaded water for a little while trying to figure out the answer to the rabbi's question, look, I mean, our job as lawyers is not to cooperate with ICE. I mean, I represent individuals who are facing imminent deportation, who are facing detention as a result of sometimes justly, sometimes unjustly, as a result of their immigration status. My job is to fight for their rights to be heard, for the rights to have the opportunity to argue that they should be able to stay in this great country. My job is not to turn them over to ICE. And my job, as a general matter, what I do for a living is to oppose what I view as unjust government action or government action that would just be adverse to my clients. I don't confront that issue ever, day in and day out. And let me just say, if somehow there was deemed to be some responsibility for me to report my neighbor or my coworker to ICE, I'm not doing it.
Let me give you an example. Let's up the ante just a little bit. You represent a client who's being sued, and your client says, the person suing me is illegal, and I'd like to turn them in to help my case.
Well,
what would you do then?
So, there's ethical restrictions on all of this. So, for example, I'm not allowed as a lawyer to threaten some sort of criminal action in order to advance a civil end. That's something I can't do. I'm not allowed to do it. It would be unethical. I believe myself to be bound by those ethical restrictions. And
what would you advise your client?
I would not advise my client that he should turn. It depends on his case. I mean, you'd have to be a little more specific, right? I'm not sure it necessarily advantages his case to invoke some sort of immigration restriction against his adversary. And even if it was, there's morality that gets involved here, and I'm not sure it would be the moral thing to do. I'm not going to be in the business of advising my clients to do that which I believe is unlawful, unethical, or immoral. And if that means that there's some advice that I could give them that would advantage their case, then I shouldn't be taking that case. That's just not, and that goes back to what I said before. Let's all be honest. There are cases that we have that we believe in more than other cases. And if we can't do our job, if it's a case that we don't believe in enough, that's not a client we should take. As Chris pointed out, we don't have to take every single case. I actually am not troubled by representing a child pornographer necessarily, but I am troubled by representing somebody who's going to do something in the future as part of this litigation that is, to my mind, immoral and unethical. I won't do it.
Chris, help me out over here. Cooperate with ICE, not cooperate with ICE. You have a firm full of attorneys. They turn for guidance. What do we do here?
Well, this part of it, as Larry said, is really straightforward. I think, the advice in your example to the client is, I'm not giving you that advice. It's just not. It's not a game we're going to play. It's an ethical violation, and to start down that road in any way, shape, or form is a real mistake. And the truth is, it's probably a terrible strategy anyway. But it's not something that any of us are going to get involved in ever. It's as simple as that. It's easy. I mean, the interesting thing is this issue is sort of playing out. I forget if it's Ocean or Monmouth County. That's now filed a lawsuit challenging the Attorney General's directive that purports to and does direct county law enforcement about what it can or should or advise the Attorney General about in respect of its cooperation with ICE. I mean, there the issue is being joined. And I don't know which court has that case at the moment, who's the lucky judge who's got it, but it's going to be very interesting to watch that play out.
Judge Wecker, you want to jump in here?
What strikes me is that everyone's comments suggest a difference between one's own personal concern about the final outcome of whatever case it is, as opposed to what the law seems to require. And the imperfect analogy to the ICE hypothetical is that for a long time it's been a rule that a judge who finds out from a hearing, from evidence before the court, that someone has been failing to report income, for example, to the IRS, or has been taking deductions, the old, what has come to be known as the Leona Helmsley problem, has an obligation to report that. Now, if you're sitting there as a judge, putting aside if you represent one of the parties, on the one hand, you're supposed to report that. But suppose you're a family court judge who knows that by reporting it, you're going to damage the children of that family who won't have money for college. I'm being a little bit broad brush about that, but I think it's a real problem. It's just not as simple an answer as any of us would like to give, considering the ultimate outcome versus what seems to be, in theory, the right or wrong thing to do.
Rabbi, so Jewish law has a concept of dina de malchus adina, the law of the land is a law we must follow. There are people living all over the world in just environments and unjust environments, good laws, bad laws. How does one balance the moral obligation to be a light unto the nations and to be a moral and an ethical compass versus following the laws of the land, which may or may not be just and fair?
How does one balance? With great difficulty. I wish I had a magic formula. I have to say that as maybe the only person here who hasn't sat on as a judge on the bench, I am somewhat confused about the implication that there are times when it's appropriate for individuals, for localities to say, we don't like this law and we're just not going to practice it. That seems to me to be very fraught and something that undermines the entire legal system. Now, there are times when laws have to be disobeyed, but in Jewish law, it's pretty clear when that is true and when it's not true. At Nuremberg, we basically decided to prosecute people for laws that didn't exist because we assumed that there was an overarching law that somehow was available to all people that they should understand. And there are things that we understand have to be wrong, and if law tells us the opposite, then they can't be followed. But there are very few things like that. When it comes to things like immigration, we may feel as human beings and as Jews that we have to get up and we have to scream and we have to yell and we have to work to change the law. But that doesn't mean that we can arrogate to ourselves as individuals the right to disregard the law. That would seem to destabilize society in general.
Yeah, I don't think. I don't think that's what any of us is saying. I mean, obviously, if there are rules, let's say, for example, there were a rule that if there were a whistleblower, that his complaint had to be turned over to Congress within a week. Let's just say hypothetically, those rules have to be obeyed. We are a society of laws, and no matter who you are, you should not be above them. And if there's a law that says that, if there were a law that said that if I come across somebody who was an unlawful immigrant, I was required to turn them over to the authorities, I would have to do that. That is the law. I have to obey it. There are ethical rules we have to obey. Nobody is saying anything other than that. The hypothetical we were given was whether we could use a negative fact about immigration in an effort to further our clients' interests. And I think both Chris and I agree that that is not something that we would feel comfortable doing or would do. This remains a country, as Justice Alvin said, of immigrants. My grandfather, my Zaidi, Aaron Holtzman, came here from Russia in 1903, in exactly that time period between 1880 and 1920. It's why I'm here. It's why so many of us are here. So immigration is something that's near and dear to us. But the law is the law. The rules are the rules. And no matter who you are, you have to obey them. And the question here is, in discretionary situations, can you invoke a rule in an effort to gain an advantage in litigation? And that's what I reject.
Chris?
I actually think it's, it's simpler in that we're advocates. They come to us after they broke the law or after they arguably broke the law. And it's our job to convince somebody that they didn't, or if they did, that they should be treated fairly. It's not our job to enforce the law. It's a lot more complicated when it is your job to enforce the law. Believe me, it's much more complicated when the law says X and you don't want to do X.
Is this something you may have
I'm just saying
theoretically struggled with, hypothetically?
That's much more difficult. The quandary a judge faces, and Judge Wecker's example of, criminal conduct coming to light during the course of a legal proceeding, that's the job, is to enforce the law and to follow the law. We have the great luxury of arguing to change the law doesn't apply here, the facts are different, etc. We don't find ourselves in that predicament, where I think in law enforcement, you do.
And this constable here could just say, I was following orders, this was the law, and I'm just following orders, and that's that?
Well, that gets us back to, I don't want to overemphasize the history of the Holocaust, but
Just following orders.
that, that's the kind of bad karma we get from looking back at that so many people, including judges, just said they were following the rules. How bad do the rules have to be before you would say, Mr. Lusberg, no, I don't have to follow that?
Rabbi, at the Simon Wiesenthal Center, is just following orders an excuse?
Just following.
It was the law. I was following the law.
I revert to what I said before, that there are
I'm a great guy. Yeah.
There are certain laws. I hate to invoke the term because it's very much out of vogue, but really what happened in Nuremberg was an appeal to what centuries before had been called natural law. And I don't think anybody called it natural law at the time, but it really was an argument in natural law that there's some things that are just so basic to who we are as human beings and what human civilization is about, that ignorance of the law or obeying the law is no excuse. But there are very few things like that. There are very few things like that. I'm hard-pressed to find another example that comes close to what went on in the Holocaust and the defendants who universally said, I was just obeying orders. There are very few crimes, if any, that rise to that.
Judge, last point, then we move on.
Yeah, one example, I think, is the regret that many judges have over having enforced the 3 strikes laws in various states and having put people in jail that, when we look back, we were following the rules, and we now know that the outcome in many cases was very unjust. And it's
a very
painful.
relevant point, which is why criminal justice reform is so important and such a big topic. Last point, Chris, then we move on.
I would just mention the one example that comes to mind as we talk about this, that we worked to try and create discretion when I was in government so that prosecutors could decide whether to actually prosecute low-level drug offenses. That seems like a really good thing. I personally thought it was a good thing, and I thought we should have done more of it. But it gets dicey when you leave the discretion up to somebody who doesn't have clear guidelines to follow. Is that person making a decision based on, well, I don't want to put this young individual into the system, into the criminal justice system, so that it's going to be harder for he or she to get a job down the road? Or is that person making decisions for other reasons? And it's very, very hard to police and enforce.
And in most cases, to Judge Wecker's point before, anytime you're sentencing someone to prison, in most cases, you're hurting their children. There are very few cases where you say the children will benefit from this, and how much of that should be a factor in the greater decisions that we're making. We have to move on. We're running out of time. One of the things that immigrants and people that are persecuted tend to have in common is a lack of funds. And they don't necessarily come in with money to pay for representation. We'll have a quick little roundtable about pro bono work. If we can go to clip number 4, please. Tevye was one such person.
Well, I'm not really complaining. After all, with your help, I'm starving to death. Oh, dear Lord. You made many, many poor people. I realize, of course, it's no shame to be poor, but it's no great honor either. So what would have been so terrible if I had a small fortune? If I were a rich man, all day long I biddy-biddy-bum, if I were a wealthy man.
So here we go. People looking for a small fortune. People are coming to a firm, to a lawyer. They're looking for representation. They have no money. One has an obligation now to perform a certain number of pro bono hours, but how does one balance the desire to do pro bono work versus the need to make a living? Chris.
Look, everybody's got to make that decision for themselves. At a big law firm, we have sort of the luxury to say we treat it like an obligation, and we do. Without getting too far into the details, and this is something I know is very near and dear and close to Larry's heart as well, it's something that we treat as an obligation. And I think our approach to it, and I'm glad to say what's become my approach, is that, in addition to giving something back and hopefully helping someone who needs help, who can't get it somewhere else, you're also helping yourself. You're feeding your soul. And we have found, and I have been a great beneficiary of being around a practice that values, that kind of work. But, for an individual who's out on their own, I hope that person has the luxury to treat it as an obligation, but it's a very personal decision that I think everybody's got to make for themselves.
Larry, what would you say?
Just to pick up on what Chris said, to me it's an honor to do pro bono work. My great friend, Governor McGreevy, I saw he was here a minute ago. He was the only one that I saw wearing a yarmulke in the front. And by the way, knows more Yiddish than anybody in my family, at least. He spends his whole life working with the people who are in the most difficult of situations, emerging from prisons. What a thing to do. And what he says, and what I believe, is that we learn more from doing that and benefit more from doing that, not only because it's good for the soul, but also just from understanding the human experience when by representing people in those circumstances. Every single time, I do a lot of big class action cases where in some ways I don't have a client, but I have a lot of cases where I represent poor people who are really in the most difficult of times. And what I learned from that is what it's like to be in the most difficult of times. For the people in this room, it's almost hard to imagine. But it reminds us every day of the difficulty that so many people in our world face. And I think I go about my life in a different and better way because I get to understand, because they've taught me. I always say that pro bono work at the end of the day is us giving, but really it's us getting more than that. And I think it's really important to remember that. There's this actually awesome part of Fiddler, which was a clip that the rabbi didn't play. Right at the beginning, when Tevye is introducing all the characters in the town, he introduces Nahum the beggar. And they show Nahum the beggar saying, alms for the poor, alms for the poor. And Tevye says, here, Reb Nahum, here's 1 kopek. And Nahum says, 1 kopek? Last week you gave me 2 kopeks. And Tevye says, I had a bad week. And he says, so if you had a bad week, why should I suffer? And there's something to that. I think probably Tevye, if he really, really dug deep, as hard as it is, he probably could have come up with those 2 kopeks. I think a lot of times we, even people in small firms who think they can't do it, think that our times are tough, but reach out for those people whose times are so much tougher. You can come up with that additional kopek.
Judge.
Just put in a quick plug because there are organizations, let me go back a step. I very much admire firms like Chris's firm, Larry's firm, that have a program to deal with pro bono representation. But as you recognized, small firms and solo practitioners can't always do that because taking on a case rarely lets you determine in advance just how much of your time and energy it's going to take. But everyone can make a contribution to legal services. There's no shame in doing it that way.
Rabbi, let me ask you a question. How does one balance the obligation to be charitable in dollars versus the obligation to be charitable in pro bono work? There are people that clearly do one and clearly do the other, but then there are people that have the tevya on one hand, on the other hand. I could write a check, I could volunteer. What's the Jewish values approach of creating a balance between who's writing the checks and who's volunteering their time?
So actually, there's a Jewish law approach, and then there's tradition. And
I thought we didn't like tradition.
Charity is an obligation. Jewish courts actually used to extract from people a yearly sum that they considered appropriate. And it was pretty sophisticated. We have a tax code you wouldn't believe. And it goes back hundreds and hundreds and hundreds of years. But we call it tzedakah. Tzedakah, people think means charity, but it's not. Maimonides points out, you've all heard of Maimonides in Guide to the Perplexed, tzedakah comes from the word tzedek, which means justice. It doesn't mean charity. It comes from the recognition that there are wrongs out there that the law itself cannot right, and that it's our obligation to do so. So I can't give you the dollar amount other than to appeal to tradition, which was 10%. That got started with us. And the great decisor of the last generation, Rabbi Moshe Feinstein, said that the same way that you're obligated to give 10% of your income to charitable causes, you should give 10% of your time. At least free time.
Chris?
10%, we're going to have to up our game. I think we were, maybe in equivalent dollars, $10 million of effort devoted by a full-time partner, several full-time associates, and all the work that all the other lawyers did. But the one thing we didn't do, and I don't think we'll ever do, is make it a requirement. People have to do it because they want to do it, and they should want to do it. But we don't say to our associates, just because it would raise our pro bono grade, that you have to. We hope that we can create opportunities and programs where people will want to, and we've been very pleased, and I think in general the community, the legal community here in New Jersey has been very supportive of pro bono efforts, and I hope that continues.
If your clients wanted you to make it a requirement, if they said we only do business with law firms that have a required pro bono time for all their partners, would that be a consideration?
How big's the client?
Big. To be continued.
We don't bend to one client.
No, but one thing, clients have shifted this landscape a little bit by requesting or looking, clients look for firms that do pro bono work. That is a factor today for the betterment of everyone.
We love partnering with our clients to engage in pro bono efforts. It's, that's a real win-win. The capitalistic side of the operation and the philanthropic side get to work together. But in terms of making it a requirement, just like Larry, it's above my pay grade, but I wouldn't be supportive of it.
So there are clients who require that firms have a diversity program. Now, that's fine because it's something you could all subscribe to, but suppose the client wants you to do something or exclude something that doesn't fit.
These are good questions. We're going to show the last clip. I'm sensitive at the time. If you give me 2 extra minutes, we'll be able to wrap everything up. If we can get clip number 5.
I'm on my way.
Where are you going?
Chicago.
In America.
Chicago, America? We are going to New York, America. We'll be neighbors.
So here's a question we'll wrap the evening up with, and then we'll hear one final word from all of our panelists. And I thank you for sticking it out. It's a question we won't have time to answer, but I challenge you to think about this for a moment. So Tevye and his family moved to America. And he said New York, but they came to New York. The Lower East Side was a little crowded, so he's going to move to New Jersey. Well, what town in New Jersey would he move to? And there are blue laws in that town, and he wants to sell his milk on Sundays. And Tevye needs a place to pray, and he may want to create a little synagogue in his house, and he wants to carry down the street on Shabbos afternoon and wants to put up the wires to make a little Eruv. And before you know it, he wants to close the schools on Jewish holidays. And all of a sudden, you have a very interesting mix in the rich and robust ethnic diversity of our state, which are issues that we as a society are dealing with today in a very real way a generation or two later, just on a larger scale. Just something to think about as we wrap the program up. We're going to ask all of our panelists to give us their final thoughts. Final thoughts on the topics discussed, and then we'll wrap it all up from there. Chris, we'll go in order. Chris.
I'll pass.
All right. Judge.
If I can go back for a moment, it seems to me that the major tradition that we do subscribe to in New Jersey is judicial independence. And we struggled a few years ago in a situation that was so contrary to our history of judicial independence that I am thankful that we seem to have recovered, and our Supreme Court has enjoyed the tradition of meeting all of that sense of independence, fairness, lack of bias.
Thank you. Give her a round of applause. Larry.
Yeah, I just wanted to say quickly about tradition as well. I'm honored to be a lawyer in a state that has a tradition of great justices like the Supreme Court justices who are sitting at this table here today. We have a spectacular legal system that is one that, of course, not everybody's perfect, but has great integrity, where the lawyers really get along well. And let me tell you, I know that, and for those of you who have practiced in other states, you know how different it is. I think we have a tremendous tradition of a combination of excellence and collegiality that, going back to the beginning, makes me proud to be in this profession. I'm glad to be part of this tradition.
Thank you, Larry. Rabbi, last word.
So, up until now, I think I've been sort of branded as a representative, for good reason, of the Simon Wiesenthal Center, but I've been speaking as an individual. Now I'll speak as a member of the Simon Wiesenthal Center. There's only one area in this mix that we have very, very strong feelings, and that is combating anti-Semitism. Whether we push the envelope in any other area, okay, people can disagree. But, Alan Dershowitz, who I have the greatest regard for, and especially as an ardent Zionist, the man can talk about the greatness of the state of Israel if he's giving a lecture on ping pong in the 14th century. He somehow finds a way of invoking Israel to good effect. But he made a mistake, I think, when he wrote Chutzpah, saying that we're permanently part of the landscape of America, and we're going to push our rights. We don't have to be self-conscious about it at all. Guess what, folks? A couple of years later, we are self-conscious. We've seen the rise in anti-Semitism, not only in Europe, but here in the United States as well, and the forecasts are it's going to get worse before it gets better. There are people who are reluctant to call the police, to call a press conference, to draw attention when there's anti-Semitic vandalism or whatever. What we believe is that that's the one area where we have a right and an obligation to push the law as hard as we can, to push popular opinion as hard as we can, because if we don't, things will get worse a lot more quickly. It's the one area where we have to remain vigorous, because without that, things do not look so good for the future.
So thank you very much. Let's give our panelists a round of applause. A couple of quick announcements. There are honey glazed challahs for everyone in the back. There are multiple exits from the building. You don't all need to go out the front. Your badges get dropped off at the front entrance. There will be a minyan for Myra of the evening service in the hallway. And I want to wish you all a very happy, healthy, sweet new year. Shana Tova to everyone. Thank you very much for joining us.